Counselor, how are you?
Doing well today, sir. Thank you.
Good. It's an arraignment form. I'm gonna need your client to sign for me. It is 100787980, all charging you with defense of murder as well. You understand that charge?
Yes,
Those
sir.
charges. 2016 838 101 0081 is charging you with defense of attempted murder. You understand that charge?
Yes, sir.
2016 838 101 00082, first degree burglary. You understand that charge?
Yes, sir.
2016 838 101 00083, possession of a weapon during the violent crime. You understand the charge?
Yes, sir.
Understand that this is just an arraignment this afternoon, that this is not a bond hearing. This court, of course, lacks jurisdiction in setting bond on you, which means that you'll be going before a circuit court judge in order for bond to be set on you. My job simply today is to inform you of all of your rights, which first being that you do have the right to remain silent. Anything you say can and will be used against you in the court of law. You understand that you do have the right to have your attorney represent you at this bond hearing, at this arraignment hearing, bond hearing, and any other hearings throughout the court. Please be aware that a warrant will be issued for your arrest if you violate any conditions of a bond order that's going to be placed on you. You have the right to be present at the trial, and if you're not there, the trial, of course, is going to proceed in your absence. Failure to appear at that trial will result in additional charges, especially if you're found guilty of the current charges. You have a right to a preliminary hearing. If you request it, you or your attorney must send it to the address listed there 10 days after the bond hearing has been set on you. You have the right to a jury trial, and if you request that, you must submit that to the court in writing. You have the right to have an attorney represent you at the trial. If you're not going to have the services of this attorney, you need to fill out that application, submit it to the clerk's office, and they'll make an application for you to actually have an attorney represented for you. You understand that? You've understood everything that I've just told you.
Yes, sir.
Any questions before we proceed? Counsel, anything from you?
No, sir, Judge.
Anything on behalf of the victims, please?
As previously noted, Your Honor, the court, that our families are here in court and they will be a part of this entire process.
Thank you. Then make sure that they are. Anything from the state? All right. Let's copy here of everything that I've just told you, all right? Thank you very much. And we are done.
Thank you, Judge.
You're welcome. There you go.
There you go. Yes, sir.
I got so much stuff up there. Which one is mine? Well, are you waiving of me reading these warrants?
We are, Your Honor. We're waiving reading of the warrants.
Thank you very much. Mr. Coleman, arrest warrant 2016 838 107 00645 is charging you with the offense of obstructing justice. You understand that charge? You have to answer me, please, sir.
Yes, sir.
Arrest warrant 2016 838 107 00655 with the offense of murder. You understand that charge?
Yes, sir.
Arrest warrant 2016 838 101 00084, possession of a weapon doing a violent crime. You understand that charge?
Yes, sir.
2016 838 101 0085 with the offense of first degree burglary. You understand that charge?
Yes, sir.
Arrest warrants 2016 838 101 0086 87 88 and 89 are all charging you with defense of murder as well. You understand that charge?
Yes, sir.
Understand that this is just an arraignment hearing this afternoon, that this is not a bond hearing. This court, of course, lacks jurisdiction in setting bond on you. My job today is to inform you of all of the rights that you will have, not only for this hearing, but all other hearings throughout the reading, or throughout the process of this, the charges here that you have. I apologize. You understand, of course, that you do have the right to remain silent. Anything you say can and will be used against you in the court of law. You understand that you do have the right to have your attorney represent you. And at this point, counsel, I see that you're here. You understand that you have the right to be present at your trial. If you're not there, the trial, of course, is going to proceed in your absence. Failure to appear at that trial is going to result in additional charges, especially if you are found guilty of the current charge. You have a right to a preliminary hearing. If you request it, you or your attorney must send it to the address listed there within 10 days after your bond hearing. You have the right to have an attorney represent you at the trial. If you're not going to use the services of this attorney, you do have the right to make that application, send it over to the clerk's office, and they will make a determination whether or not you qualify for that attorney. You also have the right to a jury trial, and if you request that, you have to submit that to the court in writing. You understand that? Any questions from me? All right, anything from, on behalf of the victims?
Yes, sir. As you can note in the courtroom